Well, this is Bob Nichols, and I'm glad to have you all here today. I'm a partner with Bracewell in the Labor and Employment section. I'm going to talk a little bit more about what I do and what Amber Dodds, who's with me here today, does. We're going to talk about a very important topic when it comes to avoiding monetary liability, which is how to avert being one of the targets of the growing number of FCRA lawsuits against prospective employers, and in particular, class action lawsuits. Let me start with some administrative points. First of all, for the attorneys on the call, this has been approved for CLE, and you will receive information about that continuing legal education credit. For those of you who receive continuing education for other licensure or certification purposes, if you ask, we can provide you with a certificate of attendance, which usually works with other organizations to obtain continuing education credit for today's 30-minute presentation. In the days following this presentation, you'll receive an email with the presentation where you can click on a link and watch the presentation or have others watch the presentation and hear both the audio and see the slides in synchronized fashion. I've practiced exclusively labor and employment law for employers for more than 32 years. I've had the opportunity and honor to work with Amber, in particular for the last 9 years on, among other things, employee and applicant background check issues. Amber and I have worked on this a great deal. This is not our first webinar on this topic. We did one several years ago. We have written articles. But it continues to be an important topic, and we continue, sometimes inexplicably, to see many employers make basic mistakes on FCRA, Fair Credit Reporting Act compliance, sometimes resulting in litigation and sometimes resulting in very expensive, even 6- or 7-figure litigation. With that said, let me explain why today's topic, the Fair Credit Reporting Act, matters. Congress enacted the FCRA in 1970 in response to concerns about corporations' increasingly sophisticated use of consumers' personal information in making credit and other decisions. The Congress wanted to put some procedural safeguards in place. The FCRA was revised several times after 1970, probably most notably and most substantially in 1996. It was clear with the 1996 amendments that Congress was concerned about protecting applicants and employees against improper use of their background data without their permission and without some degree of due process in terms of decisions made based upon the information obtained. So that legislation, as amended in 1996, required an applicant for an employment or an employee before their employer or prospective employer could run a background check to give permission, to receive notice and give permission. It also provided for a pre-adverse action process that gave, as Congress specifically pointed out, a prospective employee to bring information to the attention of the employer concerning potential errors in the information before a final adverse decision, such as a decision not to hire someone or to fire someone or not promote someone, was made. So this became a big deal in 1996, and I remember it well. We saw FCRA lawsuits early on where employers made mistakes. But what we have had happen is there are a great number of plaintiffs firms out there that look for opportunities, particularly for collective or class actions, that they can bring against employers. And they like class or collective actions because it involves big numbers and big attorney's fees awards. And with some of these statutes, like the Fair Labor Standards Act, with which many of you are familiar, or the FCRA, very simple mistakes can represent plain black and white violations of the law. And if a plaintiff's attorney can find that, it's like shooting the proverbial ducks in a barrel in terms of making money. And the plaintiff's bar, the employment plaintiff's bar, has really discovered this. And FCRA lawsuits generally, just to give you some idea, there were approximately 1,430 filed in federal court in 2010. By 2020, there were 4,350 filed, more than a 300% increase. Now, not all of these were about employment FCRA issues. Some of them were about consumer credit, what have you, but a significant number involved employment issues. And as we'll discuss, cost some organizations a great deal of money. Because the FCRA compliance, if you get it wrong, will involve you probably doing it wrong again and again with each applicant. This law lends itself to class action litigation. And even though the individual awards to those involved may seem to be relatively small, in the aggregate, the awards can be very, very large, and attorney's fees are available. And if there's a favorable award, the attorney's fees are typically going to involve 6 or even 7 figures. And that doesn't include what you pay your lawyers to defend you. So this is an incredibly expensive concern. So let's talk about dollars and cents. What are some examples that demonstrate what a significant topic this is? Let's just take the last couple of years. Starting at the bottom of the list of cases you see, Costco settled in 2018 an employment FCRA for $2.5 million. Petco, same year, $1.2 million. Frito-Lay, $2.4 million in 2018. Delta in 2019, $2.3 million. 7-Eleven, $1.9 million in 2019. And to show you it's not over with, Madison Square Garden just last year paid $1.28 million. The cases continued to be filed in significant numbers, even throughout the COVID period. For a while, I thought, 10, 15 years ago, we had FCRA litigation on a much smaller scale, but we had it. And I thought that this would run its course pretty quickly because employers would figure out what they need to be doing, and they're making mistakes, and they would correct those mistakes, and this litigation would diminish substantially. Well, that didn't happen. That hasn't happened. The plaintiff's bar hasn't run out of targets. They found more and more targets. There's 2 reasons for that. Number one, inexplicably, there are some organizations, including very large organizations, that continue to make basic mistakes, maybe new FCRA mistakes, but more mistakes even after they've been sued over making errors previously. Some of this is the result of them having decentralized hiring, where they might get it right in parts of the company, but other parts of the company, maybe over time, there are people who don't realize what they need to be doing, and they screw it up. The other reason this litigation has continued, and there continue to be targets, and in fact the suits grow and grow, is the courts, most notably the Ninth Circuit, which we're going to talk about, which is the appellate court that covers California and various western states, the federal appellate court. In my view, beyond dispute, has moved the goalposts on what employers have to do to fully comply with the FCRA. They've made their interpretations of the statute more and more exacting. So employers who believe they've got this down suddenly realize with the latest Ninth Circuit case they don't. So for those reasons, this has been a very lucrative area for many plaintiffs' attorneys. I want to explain some basics of the FCRA broadly, bearing in mind the FCRA not only covers background checks or checks conducted for employment purposes, but for some other purposes such as consumer credit purposes. I'm going to cover the real broad brush basics, and then I'm going to turn to Amber to explain to you, very importantly, the nuts and bolts, step 1, step 2 process as it relates to employers and prospective employers and background checks. The FCRA doesn't regulate all checks. It does regulate obtaining consumer reports for, among other purposes, employment purposes, based upon the 1996 amendments to the statute. A consumer report specifically includes, quote, any communication of information by a consumer reporting agency, CRA. You will hear that term. Bearing on the consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used for purposes of serving as a factor in establishing the consumer's eligibility for, among other things, employment purposes. So bear in mind, very importantly, that there's got to be a consumer reporting agency involved in procuring the information for the FCRA to be implicated. So if you go to the courthouse as an HR rep, and you look at someone's criminal history and you find they have a conviction and you act based on that conviction, that is not an FCRA covered transaction because there was no consumer reporting agency involved. If you as an HR representative or manager call a previous employer of an applicant and ask, so what did you think of Mary? Tell me. That is not an FCRA covered transaction. There is no consumer reporting agency involved. But if, as many of you do, you have a service that makes that call, now you have implicated the FCRA. Now bear in mind, I want to add this point. Many people will go to websites where they never talk to anybody to gain information on an employee or prospective applicant. Those websites where you pay to obtain information, even though you never talk to anyone, are generally going to qualify as a consumer reporting agency. So you have to remember everything we're talking about applies. So don't think you'll just quietly go to a website and search about an applicant and think I don't need to worry about that FCRA stuff that Bob and Amber talked about during their webinar. You do. So there are a variety of consumer reports, a variety of topics of background checks that are implicated by the FCRA. Criminal history that we'll talk about a lot today, driving record, prior employment verification, educational verification. You have a service check on whether someone really has their bachelor's degree from Texas A&M. Credit checks. Some of you, particularly financial institutions, will conduct credit checks. And there are some special requirements when you're doing true credit checks that above and beyond what's required with regard to other FCRA covered background checks. Let me turn things over to Amber. By the way, we're lucky to have Amber today. I've had the chance to work with her for 9 years. She's board certified in labor and employment law, and she really knows this area backwards and forwards. She's taught me a lot, and I want her to explain to you the nuts and bolts process, step 1, step 2, etc., on how the FCRA works in the employment context. Amber?
Thank you, Bob. As Bob noted, the FCRA requires several procedural steps. Prior to obtaining the consumer report, an employer must provide a disclosure to the applicant or employee, which informs that individual that the employer may obtain and use a consumer report to make employment decisions about that individual. The FCRA expressly requires that this disclosure be standalone and clear and conspicuous. You will hear a lot about those requirements in our webinar today. Second, the employer must obtain written permission from the applicant or employee to obtain the consumer report. This permission under the FCRA can be for the duration of employment. In other words, the authorization can cover more than one consumer report obtained by the employer if it is worded in the right way. However, please note some states' laws, we've got California here on the slide, require written authorization each time a consumer report is obtained. The statute provides that the disclosure and authorization forms may be combined, but they do not need to be. And as you will hear from us today, there are good reasons to keep them separate. Step 3 under the FCRA is the required certification from the employer to the consumer reporting agency. This must be in writing and demonstrate compliance with steps 1 and 2, the disclosure and authorization, all other FCRA requirements, and confirm that the employer will not use the consumer report to discriminate against the individual or otherwise misuse the information in the consumer report. While from a legal standpoint, it is the consumer reporting agency's obligation to obtain this certification, failure to make this certification could result in the employer becoming a target as well, or otherwise becoming involved in litigation against the consumer reporting agency. So an important step for the employer to ensure compliance. If the employer obtains and considers the report, but proceeds to hire the applicant or promote the employee, no additional steps are needed. However, if the employer is considering taking an adverse action based in whole or in part on the contents of the consumer report, the employer must engage in additional steps. Step 4 is the pre-adverse action notice, which informs the applicant or employee of the potential adverse action and provides the individual with a copy of the consumer report and FCRA summary of rights form. The individual must be provided at least 5 business days to challenge the veracity or completeness of the consumer report or to provide additional information about the contents of the report. This period must be a meaningful opportunity for the individual to address the report. It cannot be a mere formality. For example, the employer cannot proceed by hiring a different applicant during this period, but instead must consider additional information received from the individual about the report. This is a commonly missed step that Bob and I see, especially if the decision makers on the consumer reports are decentralized throughout the employer. Finally, step 5. If the employer proceeds with the adverse employment action based in whole or part on the consumer report, they must inform the individual of the final action and provide additional information, including information and contact information about the consumer reporting agency, confirmation that the consumer reporting agency did not make the adverse employment decision and cannot explain the reasons for it, and a notice of the individual's right to dispute the accuracy or completeness of the consumer report and to obtain an additional free report. One important caveat to these steps is that there are additional requirements for investigative consumer reports. An investigative consumer report is a type of consumer report that includes information obtained through personal interviews. For investigative consumer reports, the individual must be notified that the investigative consumer report may be obtained and that the individual may seek additional information about the interviews underlying that investigative consumer report. While we will not delve deeply into investigative consumer reports today, an important note here is that you need to understand the scope of the consumer report provided to you by the consumer reporting agency, so that if any element of that consumer report would qualify as an investigative consumer report, you are sure to meet these additional obligations. Bob, there has recently been case authority interpreting the FCRA on these requirements, particularly on the disclosure. Can you tell us about those cases?
Thank you, Amber. It is shocking to see what the Ninth Circuit has done in terms of its strict approach to what is required of a FCRA disclosure. We're going to talk about the chronology of decisions we've seen from the Ninth Circuit, and then we'll talk briefly about why, even if you're not in the Ninth Circuit, this Federal Circuit's decisions are still important to you. I do want to note that a lot of the strictness we see from this Court of Appeals also can be found from the FTC, the Federal Trade Commission, that has regulatory authority with regard to the FCRA. The FTC also, for example, as we'll discuss, takes a very strict view of the standalone disclosure requirement, clear and conspicuous language, etc. With that said, the series of cases in the Ninth Circuit that created particular concern, began in 2017 with Syed v. MI LLC. A gentleman applied for a job, and the employer presented him with a disclosure. He was a California employee, and that disclosure included something Amber and I have often seen in past years from employers, which is they put release or disclosure language in their disclosure. They want the person to agree they're not going to sue them over what they're doing. And what the Ninth Circuit said in Syed is you can't do that. They say you can't conclude that the disclosure consists solely of the disclosure if you've got release or waiver language in the same document, and therefore you render your entire process invalid. So the focus was placed with Syed on avoiding extraneous information in your disclosure. You want a bare bones, as we'll discuss, short FCRA disclosure in a standalone document. By the way, to show you how serious things are, the Ninth Circuit said that including waiver language rendered the violation in Syed willful, and therefore resulted in the availability of enhanced damages. If we thought that Syed was an aberration from the Ninth Circuit, the Gilbert versus California Check Cashing Stores case taught us that it was not an aberration. It was what we should expect going forward from the Ninth Circuit with regard to its view of the FCRA disclosure requirement. In this case, again, the Ninth Circuit found that an employer's disclosure did not consist solely of the disclosure, but included extraneous information. First, the disclosure was not clear because it included the following sentence, which the Ninth Circuit deemed confusing. Open quote, "The scope of the notice and authorization is all-encompassing, however, allowing Checkmart to obtain from any outside organization all manner of consumer reports and investigative consumer reports now and if you are hired throughout the course of your employment to the extent permitted by law." Sounds like it was drafted by a lawyer, and it was a mistake because it's not required, and it's long and it's confusing. I have to acknowledge that. Specifically, the Ninth Circuit complained that at the beginning of that sentence, it does not explain how the authorization is all-encompassing and how that would affect the applicant's rights. The Ninth Circuit further recognized that the second half of the sentence, okay, think 8th grade grammar class, okay, says that following the semicolon, the sentence lacks a subject and is incomplete. Remember subjects and predicates? It suggests that there are some limits on the all-encompassing nature of the authorization, but it does not identify what those limits might be. You can tell the danger, including extraneous information, in your disclosure. Not only do you endanger compliance with the standalone requirement, you endanger your compliance with the requirement that the disclosure be clear as well as conspicuous. Second, the Ninth Circuit observed that the disclosure form included information concerning state disclosure requirements, not just federal FCRA disclosure requirements, not just California state law disclosure requirements that exist, because after all, the applicant at issue, Gilbert, was in California. But to try and do things in an efficient way, like many of you do, they had a single form that applied across the country. So it said, if you are in New York or Maine, we all, also bear in mind the following. So they wanted to do something sensible. This employer have a uniform form. And obviously, I would think the applicant knows they're not in Maine or New York, so they shouldn't worry about that language. But shockingly, the Ninth Circuit said you cannot address in the disclosure state law disclosure requirements that are not applicable to that applicant. That's viewed as extraneous information, which renders the disclosure not clear, and also, by the way, presumably violates the standalone requirement. So the net result is you have to be extremely careful and minimalist in your approach to the language of your disclosure, and you cannot, for example, if you have unique state disclosure requirements, and Amber's going to talk about some of those later, you cannot address those in the same document that you do your federal FCRA, at least in the view of the Ninth Circuit. Amber, I'm going to turn things back to you to address two more Ninth Circuit cases that show that the Ninth Circuit continues to move the goalposts and continues to issue troubling decisions.
Thank you, Bob. Let's talk about Luna v. HANSEN and Adkins. In Luna, an applicant alleged that the employer providing the FCRA disclosure on a separate page, but together with other employment application materials, violated the standalone disclosure requirement. In a short decision providing some respite from the changing landscape in this area, the Ninth Circuit rejected the plaintiff's argument, holding that nothing in its precedent would prevent providing a standalone FCRA disclosure contemporaneously with other employment documents. In other words, no precedent suggested that the disclosure must be distinct in time. Instead, the Luna court reiterated that providing the standalone disclosure, even alongside other application materials, was, quote, precisely what the FCRA requires, end quote. Notably, Luna also analyzed an FCRA authorization form, which was separate from the disclosure, but included other notices, waivers, and agreements unrelated to the consumer report. The Luna court concluded that the standalone requirement did not extend to the authorization form. In other words, it applied only to the disclosure. So there was no FCRA violation based on a separate authorization form having these additional contents. However, Luna demonstrates the type of novel legal arguments being made in the FCRA sphere, arguments that seem foreclosed by clear statutory text, but are still being pursued against employers. The next Ninth Circuit case, Walker v. Fred Meyer, did not turn out so well for the employer. In Walker, an applicant challenged the language of the disclosure form as containing extraneous information. The court confirmed that disclosure forms cannot contain any extraneous information, even if it's related to the consumer report and even if it's well-intentioned by the employer. Just like Bob mentioned, having, for example, state law consumer reporting information on the disclosure form could be extraneous information. The Walker court first set out to describe what information was not extraneous, explaining that the disclosure could include a plain statement that a consumer report was being obtained for employment purposes, and a concise explanation of what a consumer report entails, how it will be obtained, and for what employment purposes it may be used. Beyond that, nothing more could be included. Or as the Ninth Circuit put it, the standalone requirement is unambiguous and means what it says. In what the court described as a case of first impression, the court reviewed the 5-paragraph disclosure and confirmed that the first 3 paragraphs, setting forth what a consumer report was, why it was being obtained, which consumer reporting agency would prepare it, and what it may include, did not violate the standalone requirement. Yet, additional paragraphs in the disclosure, which the court described as appearing to have been included in good faith in order to provide additional useful information, rendered the disclosure non-compliant. You can see that language on the slide. It explained the individual's right to inspect the consumer reporting agency's files. The disclosure form was rendered non-compliant because information on how to, for example, inspect those files may have distracted the applicant from his rights under the FCRA. That information, the court held, could and should have been provided in a separate document. Notable in Walker is that the employer intentions did not matter at all. The disclosure must be straightforward and limited. There is simply no exception for information that is related to the consumer report or that the employer believes may be useful or helpful to the individual. Bob and I have discussed several recent cases, all of which are from the Ninth Circuit. You may wonder how these cases affect your operations elsewhere in the country. Bob has some thoughts on this.
Thank you, Amber. It is correct to say that the Ninth Circuit has taken a unique position and that it impacts employers not based on the West Coast. First of all, many employers think of the Ninth Circuit as synonymous with the state of California. Actually, that federal circuit includes Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, as well as Guam and the Northern Mariana Islands. And therefore, you may have no operations in California, but you may have operations in some of those other states. And as a result, you might not only find yourself in litigation in the Ninth Circuit, you might find yourself in class action litigation where they are bringing in applicants even nationwide involving your organization. Another reason the Ninth Circuit is important, even if we're not talking about Ninth Circuit litigation, is that there are many federal judges, for example, many progressive federal judges who find the progressive views of the Ninth Circuit appealing and sound. And there's no guarantee that a judge in another circuit won't take an equally strict view with regard to the FCRA. Finally, if you are risk adverse, like Amber and I are risk adverse, you try and take the approach that is most likely not to be challenged. So in this arena, if you are smart and if you are risk adverse, you will formulate your disclosure and the rest of your FCRA process that complies with the view of all of the circuits, including the Ninth Circuit. One quick note that we continue to see employers misunderstand is when you present the pre-adverse action notice, you must provide the employee with a summary of consumer rights. That form's language changed. Wasn't a big change, but it changed in 2018. If you use the pre-2018 form, as many employers continue to do, you are violating the FCRA. As you can see, the the change at issue with regard to new language about the right to have a security freeze. If you don't use that new post-September 21, 2018 form, you are not following the FCRA and you're subject to liability.
One of the most tricky aspects of the background check process for multi-state employers can be ensuring compliance with state law as well. As you can see on this slide, many states have mini-FCRA laws that further restrict or regulate the background check process. These laws affect the process in a variety of ways. For example, some state laws limit the type of information that may appear on a consumer report. Other states, such as Oklahoma, Minnesota, and California, require notice forms include a checkbox for applicants to receive a copy of the consumer report, even if no adverse action is contemplated by the employer. In New York is another example. There's a requirement for specific additional disclosure with additional information about the New York State Corrections article if the employer is obtaining criminal history information. Finally, other states such as North Carolina require that additional notice be provided to consumers regarding their right to obtain a security freeze on their information. As you can see, state laws can complicate the background check process, and as Bob discussed, state law disclosures often may not be included on the FCRA disclosure form. So what are employers to do? Let's talk about some action items. First, remember that you cannot legally rely on your consumer reporting agency for full compliance. In each of the cases that we discussed today, a consumer reporting agency was involved. You can begin by proactively reviewing your contract with your consumer reporting agency. While you cannot contract around legal liability, your contract can address issues of indemnity and insurance to set out what will occur if litigation arises. Similarly, you can select respected consumer reporting agencies as your vendors. Those agencies have the resources to monitor continuing compliance and respond to changes in the legal landscape. You may certainly ask your consumer reporting agency how they monitor for developments and how they will notify you of necessary changes as they arise. You can also centralize the background check process at your organization. As you have heard during our webinar, the FCRA background check process requires attention to detail and consistent care. Accordingly, it's important to ensure not only compliance with the process, but also documentation of that compliance.
As you can tell from our discussion today, a major focus is getting the disclosure form right in light of the Ninth Circuit case authority from the last 3 years. So let's talk about action items in that regard. As Amber's indicated, you should be auditing your forms and your process to make sure it's fully compliant in light of these case law developments. And you should assure that your disclosure form is a standalone form. Many of you do this online. That means a standalone screen. There shouldn't be any other information that appears on the screen with the disclosure, including no information about state disclosure requirements. Don't include waiver language. You don't need it. Keep it simple. Don't explain the process on the same screen with the FCRA disclosure. You saw the no good deed goes unpunished result of that in the Ninth Circuit. And do not forget the pre-adverse action notice. Particularly, again, if you have a lot of people involved in the process, a well-meaning regional HR rep or department head who, if charged with completing the process, might just accidentally jump to the last step and notify the applicant that they haven't been selected. Maybe call them and tell them they haven't been selected because of information obtained. If they do that before you've gone through the pre-adverse action process, you violated the law. And again, that's one of the reasons Amber and I are big believers that this process throughout your company should be centralized and done by people who know the FCRA requirements backwards and forwards. Understand the requirements of these state mini-FCRAs that Amber referred to. There are some unique requirements. Part of your audit needs to be, are we compliant with applicable state laws that impact us in addition to federal FCRA? By the way, do not forget, we don't have time to address all of these other issues, but they're important concerning laws besides the FCRA and state FCRAs that impact the background check process. Many of you know about ban the box laws that have become almost ubiquitous across the country. You can't, you generally in many states and in many localities cannot be asking criminal history information on an application, and in many of those jurisdictions, when you can ask criminal history information and what you can do with criminal history information has become highly regulated by these ban-the-box laws. Also, a very important topic with background check information is not using it in a manner inconsistent with discrimination laws, such as Title VII or the Genetic Information Non-Discrimination Act, GINA. You need to make sure that you treat everyone equally. You need to make sure that you are not using, for example, criminal history information or credit information in a manner that has a statistically significant disparate impact on minority groups unless you're prepared to prove the business necessity defense of Title VII. Also bear in mind, some state laws have particular rules barring the use of credit information altogether for employment purposes. They don't want people with poor credit excluded from jobs in total. And one of the reasons for that is because it has a disproportionate impact on minority. Be careful of another growing state and local law trend, which is laws that limit inquiries into salary history information of applicants. That again is intended to limit the gender discrimination impact of requesting salary history information where, for example, a highly qualified woman may have had a job at a lower rate of pay and you feel at liberty to offer her lower pay than you might another applicant, such as a male applicant, because you feel like you can get away with a lower offer. That's why many states are limiting your ability to ask during the hiring process about applicants' salary histories. Also bear in mind, finally, record retention and disposal requirements. Under Title VII, you essentially have to keep all these hiring materials for at least a year. Sometimes there are state law requirements that are longer than that. And there are disposal requirements. If a supervisor prints out a consumer report on an applicant, and when you're done with the process, throws it in her or his wastebasket, they have violated the FCRA. You have to follow careful, secure disposal rules for consumer reports. Well, that's all we have today. We've enjoyed talking with all of you. We hope you found it helpful, and have a super day.